From the Sunshine State, this is Tampa Bay's Tan Talk.
Welcome to Tampa Home Talk with your host, native Tampa real estate girl, Katrina Madewell, a full-time, passionate, out-of-the-box thinker, love for home ownership kind of realtor with over 21 years of combined mortgage and real estate experience. Tune in every week at this time for expert advice on everything you need to know about home ownership, finance, maintaining great credit, building wealth, and making your everyday life better, and how you can be financially successful today and tomorrow. Remember, love where you live or let Katrina fix it. Now, here's your host of Tampa Home Talk, Katrina Madewell.
Good afternoon, and you are listening to Tampa Home Talk. This is your host, Katrina Madewell, on the Real Estate Radio Network. Thank you so much for joining us today. I'm very honored to have in studio Perry Gruman with Gruman Law about our show topic today, which is probate, will, and estate planning. It's some of the things I don't think anybody ever wants to talk about, including myself, but we're going to talk about it because it's important, and we're going to talk about some of the mess that you will leave your heirs with if you do not deal with it. Thank you for joining me, Perry. I appreciate it.
Thank you. It's great to be here.
So, probate. Let's talk about probate and break it down for the lay terms. Like, what is probate exactly?
What is probate? Probate, to make it simple, is a process under the law where generally a court determines after a person dies what persons inherit the property of the person who passed away. And typically that's either determined whether or not the person had a will or the person did not have a will. If the will is enforceable, the will generally, with some limitations, will determine who inherits the property. If a person does not have a will, there's different laws in place which determine who the beneficiary of the estate will be in that case.
It's interesting. You and I were talking. It's so inexpensive and simple and easy to actually just put together a will in advance, outlining the different things and essentially talking about, who's going to get what. I know we talked about you can even include future assets and that type of thing. So talk about, well, I guess we'll go into planning first, and then we'll talk about some of the things that happen if you don't plan. So your office, it's one of the things that you specialize in probate. And you said you have a simple package, really, that starts at $500, and it depends on your assets and that type of stuff.
Right.
But what does that include?
Typically, a simple will package is what we call it. A will package includes a simple will for the person, which is a will is simply a document which in general terms identifies the assets of the person and specifies who is to inherit those assets. So that's the first document in the will package. The second document is a durable family power of attorney. That typically is a document that one person gives to another, typically a family member, which allows the family member to act on behalf of that person in different matters. Usually it's a comprehensive power of attorney. So, for example, a power of attorney typically would allow a spouse or child to transfer property on behalf of the principal, to do banking transactions, to make healthcare decisions on behalf of the person, to admit the person in a hospital or a nursing care.
So the power of attorney covers not only post-death, but pre-death.
Actually, it only covers pre-death.
Okay.
Generally, under Florida law, power of attorney is deemed canceled or void upon the death of the maker of that power of attorney.
Thanks for clarifying that. See, I'm so green to this stuff. That's why I have you. And so the last part to that package, because there's three pieces,
there's
right?
Actually four.
Four.
The third is a living will, which in general terms specifies whether or not life-saving measures are to be put in place for the person signing it. For example, whether a respirator would be used, a feeding tube, etc. And the last document would be a a healthcare surrogate document, which is sort of like a power of attorney, but it's a document that specifically delegates the making of medical decisions on behalf of the person signing it.
How does that vary from the living will? Because they sound so similar to me.
The living will refers to life-sustaining measures typically. And it's used in conjunction typically with medical service providers and end-stage decisions that the family has to make. For example, if someone is in a vegetative state, highly unlikely to improve, often a decision will have to be made whether to sustain procedures for a period of time. And most people would want a living will which would specify, at least in some circumstances, that those life-sustaining procedures not be carried on at least after a certain physical condition is reached.
So, and usually, I mean, well, the person putting that together, they can express their wishes, right? Whether it's a spouse or a child, can they choose the person they want to determine that? They
can choose the person, and they can also nominate a successor or alternate person.
It's interesting. So what's the purpose of probate?
The purpose of probate is to have a estate plan which would refer to all of the assets of the person and determine who is to inherit those assets upon the death of that person. So
when someone passes, does it automatically go into probate regardless of the amount of time?
The general rule is that the only thing that goes into probate would be an asset that was titled solely in the name of the deceased. So that, for example, as most people know, if you own real estate in the name of husband and wife, husband dies, the wife would inherit that asset outside of probate. It would be title would transfer by operation of law, so you wouldn't have to have a probate. So,
right.
So there's a lot of situations in the law where probate does not apply.
So they couldn't kick a spouse basically out of their house if one passes, which makes sense.
If both their names are on it, correct. In other cases, it depends on the nature of the asset. With personal property, for example, if two or three names are on an automobile title, and one person dies, unless it's specified as joint tenants with the right of survivorship, it would be determined to be tenants in common. And tenants in common, the interest of the deceased person would typically have to go through probate to clear that title.
I thought tenants in common usually just divvies what's left to the remaining owners.
If it's normally you have to use magic language. Tenants in common with right of survivorship, for example.
Gotcha.
Without that, it often does have to go through probate.
So the interesting thing that I know when you and I talked, it was something that I never thought about, and that's why I love the planning meetings. I love to have people like you on my show because I always learn so much. But one of the things that I remember I heard you say, and I thought it was so interesting, was, once you have this will prepared, the importance of the original and where you'll store it. How will you do that? And we talked about some of those details. Can you share?
Sure. It is important to have an original executed will. And just so we can sort of lay a framework, a will is a written document. It has to be signed by the testator or the person making the will. In Florida, it has to have two witnesses. Each witness must witness the testator, the maker of the will's signature, and each other's signature. Under Florida law, it does not have to be notarized, but if it is notarized in a specific way, which is referred to as self-proved, then it's typically much easier to admit it to probate, which means to have the judge accept the will for probate purposes. And under Florida law only recognizes an original document will, a document signed by the maker of the will. In other words, we don't have electronic wills.
Right.
You can't email a will.
Which that's important. I think in this day and age, it's super, super important. And I had no idea that you would need the original.
You do need the original. In some circumstances, you can what's called reestablish the original will. But the problem with that, and it often leads to disputes, is that there's a presumption under Florida law that if you only have a copy of the will, that the maker of the will intended to revoke the original. In other words, there's a presumption that the maker destroyed it or threw it away intentionally with the intent of revoking it. So you have to rebut that presumption if you're trying to probate a lost will or a copy.
So can we share a story on that? Like why? I know you shared a couple of examples, but just in general.
Well, I had a case recently where there was a will. The will, it was a grandmother, but the will left everything to her stepson, who she had not adopted legally. And the granddaughter, who would have adopted without the will.
Meaning that the state would have pulled for her?
Well, under Florida law, if you don't have a will, then Florida law determines who inherits your property, whether you want it to go that way or not. And I mean, typically it's spouse and or children, but it depends on whether or not the spouse is the parent of all the children. The formulas are different depending on the specific family dynamics.
In this day and age with the blended families and stuff, I imagine that's ever so important.
Right.
So you had this scenario where the maker of the will left everything to her stepson. She actually had a granddaughter.
Right. And what we believe happened is that the granddaughter broke into the residence of the grandmother, stole the original will. My client, who was the stepson, only had a copy of the will. So we had to prove or reestablish the original will as a copy. It was contested by the granddaughter, and the same presumption comes into effect that if you don't have the original will, then it's presumed that the maker of the will intended to revoke that will. And so we had a battle, and we ultimately resolved it by way of a settlement, but it just shows the importance of keeping the original will in a safe place.
So we have to take a quick break, but when we come back in just a minute, we're going to talk about where someone should store that original will when they get it prepared, and also some other key importances at the time that they're actually making the will. And this will, modern day technology will kind of help you, if you will.
Okay, great.
We'll be back in just a minute.
Hi, this is Aaron Davis, owner of Hillsborough Title. Hillsborough Title is a local, family-owned title agency here in Tampa Bay. Our service, strength, and knowledge make us different. We've served Tampa Bay area for over 30 years. From Polk County to the Gulf, Pasco to Manatee, Tampa Bay, we've got you covered. Call us at 813-712-8888 or visit us on the web at thebesttitle.com. That's thebesttitle.com.
Ask me about an inside secret to save several hundreds of dollars on your annual homeowner's insurance premium. Text the word WIND, W-I-N-D, to 813-377-2775. Again, 813-377-2775.
I'm John Rakowski, the broker with Charles Ruttenberg Realty. If you are a real estate agent and want to keep more of your hard-earned commission, call me today at 727-538-9200 extension 2. This call will change your real estate career.
Hi, I'm Ike Santonio Thomas, director of Salitas House, where we offer homeownership workshops, pre-purchase counseling, foreclosure intervention counseling for homeowners at risk of losing their home, financial coaching for adults and teens. Come sign up for our program where if you save $1,000, we'll give you $1,000. Call us 813-425-4847. Again, 813-425-4847. You can like us on Facebook or you can find us on the web, salitashouse.com.
Hi, Hi, this is Melissa Rogers, owner of SEC Inspection Services, where we offer full inspections and insurance inspections. Give us a call at 727-786-4663 or visit us on the web at secinspection.com.
Welcome back. You're listening to Tampa Home Talk. This is your host, Katrina Madewell, and we are back discussing wills, probate, planning, estate planning, all the things you need to know that you really should be dealing with before it's your time to go. In studio, we have today Perry Gruman with Gruman Law. You love my sense of humor, don't you?
Yes.
It's very lighthearted. I can be serious when I have to be, right?
Yes.
So I know we were talking about in the prior segment, so if you missed any part of Tampa Home Talk today, you're really going to want to catch the whole show in its entirety, and you can do that via a podcast because all of our shows are hosted there. We're also on Facebook, Twitter, and across the web at Tampa Home Talk, and also on tampahometalk.com. So we were talking about making the original, and you shared a story where you had, you represented a stepson where the grandmother's intentions, you believe, were to leave everything to him or her, whoever that person was, and there was a granddaughter that actually would have what's the legal term for that? The way I know, like in real estate, it's a lien line, right? Like your hierarchy of order on who gets what.
Typically, we would refer to the granddaughter as a biological heir,
okay,
which is a blood relative. My client was the stepson who was not a blood relative, and since he wasn't adopted, an adopted person is treated for almost all purposes under our law as a blood relative, but he wasn't adopted. So therefore, if there hadn't been a will or an enforceable will, the granddaughter would have inherited everything.
So we talked about that, whether it happened or it didn't happen, whatever remains to be seen. But I'm sure, and there's a lot of cases where it does, where the only heir, in this case, the granddaughter, would go into the person's home, take the original will. And then, like you said, there's a assumption under the law that the intent of the will intended to destroy it or get rid of it or redo it or whatever.
Exactly.
So where's a good place to store? Well, before we get a good place to store it, we talked over lunch and we were talking about, and I thought this is brilliant. Like if and when the next time I do a will, this is what I'm going to do. But we talked about video, right? And like where you should actually do that will. Well,
I recommend that a will be executed at a lawyer's office. It doesn't have to be under the law, but if it's executed as a lawyer's office, most lawyers will retain a will indefinitely.
So you retain an original copy too?
Well, typically not.
Okay.
Typically, the original would be retained by the maker of the will, and then at a later date provided to the personal representative nominated under the will. So my recommendation typically is that an original will should be left in a safe deposit box in the name of either the maker of the will or the personal representative, and that if it's in a safe deposit box with only the name only in the name of the maker, then the maker should leave written clear instructions to the personal representative as to the location of the safety deposit box, etc. We normally recommend
originals. Is that possible?
I don't do that. I typically don't do that. There's nothing that I'm aware of which prohibits that. And if you're going to do that, they need to be identical in every respect, including the witnesses, the date, and I wouldn't recommend that necessarily.
Gotcha. It's interesting to get your, if I were to do it, I would say, oh yeah, I probably need an original, like one I'll keep at home or safety deposit box. You retain another one with the attorney or another family member. It's interesting to hear your opinion on that. So safety deposit box, and then we also talked about especially because I imagine you see a lot of people that finally deal with the fact that they need to have a will. They deal with it maybe at an elderly age, or perhaps their health is deteriorating, whatever it is. And you mentioned it's the importance of the person even taking into the attorney's office to do the will. Right. And actually, you touch on a very important point. If someone is elderly or of questionable mind, if they suffer from a mental disability or a mental illness, that we have that a lot. And then because an attorney has an ethical obligation to ensure that the person signing the will is mentally competent to do so. Right. And we will often, if it's
a questionable situation require that the client or a close family member of the client obtain a doctor's letter attesting to the competency of the person making the will.
That's a lot of responsibility for you as attorneys, isn't it? I would imagine, because you may get an hour with somebody. If they're way off, but what if they have the beginning stages of dementia?
There's a lot of borderline cases. It's also the responsibility of the notary, which can or could not be the lawyer. But the notary under Florida law has the same ethical duty to make sure that the person signing the instrument, whether it's a will or any other legal document, has the legal capacity to sign it and understands in at least a general way what the document says.
Absolutely. Yeah, we've encountered that even on the real estate side,
right?
Where I've notarized stuff for other people, and I'd say, I'm not going to do this. Not comfortable with what's going on here.
Right.
So I want to share, just being that we're touching on that, something that happened in my life pretty recently that was personal to me. And it was a different state. Obviously, the laws are different in that state. But just with respect to Florida and using the story. So I had an aunt, she's my grandfather's cousin. Okay. And so my grandfather is her last heir, like her last immediate heir, because her husband passed on several years back. Her daughter actually died of a stroke, and it was just her, by herself in Vegas, kind of always lived there, moved away from the family many years ago, loved living there. But what happened was, this guy that, he was her financial advisor, financial planner. He basically, I guess from what I understand later, worked with a lot of elderly people and essentially helped her for many, many years. Well, when Mike was alive, her husband and even her daughter Shelly, there's no way that, that guy ever would have taken advantage of her. But being that they were both gone, she was by herself, she was getting elderly, dementia was setting in. He basically took it upon himself. He took her to an attorney's office to redo her whole will and put him as the only
beneficiary.
Yes. So as you can imagine, when we got involved, which was actually before my aunt passed, it ended up being just a mess, like an absolute mess. We wish we would have brought her back here, but it's a long story short. And so that went through the probate process for a long time. As a matter of fact, it's still in probate.
Wow.
But and she had a pretty big estate, which had a lot to do with it. And they had to go through that process where the heirs have to verify who they are. They have to kind of chase bloodlines,
right?
Whatever goes into that. And I know you said you have a private investigator you work with and stuff, but in that particular scenario, I thought, it's interesting because you have this guy that's clearly taking advantage of my aunt. And, took her to go see his attorney or somebody that he worked with to have his whole will remade out to her, when he knew very clearly that was never her intention. Her intentions were my grandfather, his brother, which had actually passed. And she left the will where if somebody passed, it would be divvied up among the remaining, beneficiaries. So it was my grandfather, his brother, the Stroke Foundation, because they really took care of her daughter when she passed. So she left 25% to my uncle, 25% to my grandfather, 25% to the Stroke Foundation, and 25% to a dear friend of hers that had been a lifelong friend forever.
That was the earlier will.
That was her will. The earlier will, which now there's technically two, right? Because this guy...
I see.
Clown took her to an attorney's office to redo it. And so what happened was he, when she first started getting dementia, she was getting older, couldn't really care for herself. He hired these girls to come in and kind of, clean her house up and maintain. And then I think when he realized there was an opportunity for him to kind of jump in, he did. But I guess what he never expected was that, that these girls that were looking out for my aunt would actually contact us and say, hey, your aunt's at risk because he's trying to put her into an assisted living facility. We know she never wanted that. We know she told you guys that. She told us that. And here this guy's trying to put her in an ALF and, basically just take over her estate. And so that's when we got involved, was we ended up going out there. And when we got there, we actually called the police, and he was chucking around town, taking her to different assisted livings. Well, as far as we were concerned, she should have been at home in her own residence. And we waited and waited for several hours. And when she wasn't there, we called the police. And so it turned out that there was a whole bunch of drama, in prior weeks where people were calling the police on each other. And this guy was just a mess, right? As you can imagine. So can you imagine how much fun that would be to untangle?
That's a situation where there's a late executed will, which changes the presumed correct scheme, which is typically family members take. And so in this situation, a non-family member took an elderly person to his lawyer, probably.
Yes.
And then instructed the lawyer to make a will and make this person the sole beneficiary. The law in all states has a concept called undue influence, and that's a common litigation area where in many cases the law will undo a will that is obtained by a person, typically but not always a non-family member, who procures a will for the benefit of that person, making the person either the sole or substantial beneficiary under the will, and normally substantially changing the will from the terms and conditions of a previous will. And
they got doctors involved. I mean, they were asking, what her mental capacity was when the first will was executed, what it was like when the second will was executed, and they discovered she was diagnosed dementia in between those two wills.
Interesting.
So it was quite something I've never experienced before.
One element that you can put in a will, which is sort of advisory, it's not mandatory, but you can appoint a pre-need guardian, which is basically a statement that says, if I ever need a guardian, I want person A, B, or C to be my guardian. Typically a close family member, but it doesn't have to be. And if you're able to do that, at least the people who care will know who you want to step in and make those decisions on your behalf if that happens.
It's funny that you mentioned that, because the state of Nevada actually had, she listed her friend, one of the ones that was a 25% interest beneficiary, as her guardian, to take care of her. And the law as such says that they will not let someone that lives outside of the state of Nevada be a guardian.
Interesting.
And she had already moved, she lived in Nevada for years, but then she lived in Texas.
Even though she was a family member?
She wasn't related to her.
Oh, she wasn't related.
Yeah, she was one of her close friends. She had been friends for years, lived across the street.
Right.
But it's interesting how things can play. So
how did that case turn out?
Well, it's still in probate. I mean, it's still they've done a temporary distribution, or I guess a partial distribution on her estate, but they're still liquidating assets in her home.
They're still fighting over the validity of the second will?
No, that's already been.
So the second will was thrown out.
That's right. Yeah. Yeah, and that was
probably expensive to get that done.
I'm sure it was, which there was an advance, and plus I'm sure they took a portion of the estate. So, whatever, it is what it is. But so what were you were touching on? There's something you can put in there. Is there anything you can do, like in the state of Florida? I don't know what the laws say.
You can appoint a pre-need guardian. There's also a concept under Florida law called a standby guardian, which in some circumstances you can appoint, which is a more formalized procedure. That says if you're ever in need of a guardian, you appoint a specific person to take over your affairs at that point.
Is there anything in the state of Florida that says they have to be a resident here? Do you know?
Not to my knowledge.
Okay.
No.
So
actually, a personal representative, unless they're a family member, must be a resident of Florida. So that there actually could be a similar guardianship provision. I'm not certain.
Yeah, well, I think a lot of our state laws are similar,
yes.
So it's possible. So, and how does, let's say if my aunt had done a video, like we suggested, right, where she was full sound mind and body after she lost her husband and her daughter, she redid the will, and at this point she had it videotaped, right, and it was notarized and done in the attorney's office and stuff, which was her attorney that she had for years. How, what part would that play when it actually went to court?
The problem in your case is that probably wouldn't help, because the issue in your case is whether the second will was valid. And normally, if the second will is not valid, then either the earlier will is revived, or the law determines that the person is treated as if the person didn't have a will. So the intestate law would take over, and then which is basically a statutory formula for determining who inherits if you don't have a will. So that's very, very troublesome case like that, it's probably likely that she didn't have very close family relationships in her geographic area.
No, because they were all originally from the Columbus, Ohio area, and they all kind of migrated. Like my other uncle lived in Kentucky. My grandfather lived here. They moved to Vegas. So they kind of spread out.
One way you can sort of protect against that is by placing assets in a inter vivos trust, and that's essentially a document or an arrangement where assets are held by a trustee for the benefit of a beneficiary. It would have been your aunt in this case. The trustee could have been you or other family members. And once a valid inter vivos trust is established, then it really doesn't matter what the mental condition of the person who creates it becomes at a later date. And so that's an extremely effective way of preventing a bad guy or girl from coming in later and stealing assets, basically.
Well, it's just, the intentions were just bad. I mean, from taking my aunt to an ALF, really. I mean, she had always expressed her whole life that she never wanted to live there. And she had enough money to have a caregiver in her home for the rest of her life. So it never should have happened.
Often in cases like that, you will get into a situation where a guardian needs to be appointed. So
it happened. And it wasn't fun because we got involved with Nevada court systems, which I don't think are as fair as they are here.
And did you have a public guardian appointed, or was it a public guardian?
And they really
most
probably
people aren't
shouldn't
happy
have.
with that. Typically.
Yeah, well, she had enough assets, so they said she never should have had a public guardian. So, I mean, really a private, I guess, should have. Anyway, you're listening to Tampa Home Talk, and this is your host, Katrina Madewell. Perry Gruman and I are having so much fun today talking about estate planning and what ifs and all those things that you probably never thought about. So when we get back in a few minutes, we're going to go over some of those frequently asked questions that Perry gets and also give you a few more scenarios so that if you can relate directly to one of them, you can call his office directly and actually get connected to get that will put together. We'll be back in just a minute.
Hi, this is Melissa Rogers, owner of SEC Inspection Services. We're so glad that you're listening today, that we're offering you a special deal. If you're purchasing a home, you can have $50 off your full home inspection. And if you're already a client of ours, we're offering 10% off of any other service that we offer. Just give us a call at 727-786-4663 or visit us on the web at secinspection.com.
If you are a real estate agent and want to keep more of your hard-earned commission, call me today at 727-538-9200 extension 2. This call will change your real estate career.
Curious where your credit score is? Text the word credit to 813-377-2775. Not sure where it needs to be in order to buy? We'll tell you. Simply text the word credit to 813-377-2775 for access to your credit score now.
Hi, I'm Ike Antonio Thomas, Director of Salidas House, where we offer homeownership workshops, pre-purchase counseling, foreclosure intervention counseling for homeowners at risk of losing their home, financial coaching for adults and teens. Come sign up for our program where if you save $1,000, we'll give you $1,000. Call us 813-425-4847. Again, 813-425-4847. You can like us on Facebook or you can find us on the web, salidashouse.com.
Curious what your Tampa home is worth? Here's an easy way to find out what homes like yours are selling for in today's market. Text the word value to 813-377-2775 for a free report on Tampa house prices. We'll send you a free report with up-to-the-minute statistics based on all homes for sale sold in your neighborhood over the last 6 months in all price ranges. To get your free report on Tampa Bay house prices, just call or text the word value to 813-377-2775.
Welcome back, and you're listening to Tampa Home Talk. This is your host, Katrina Madewell, on the Real Estate Radio Network. Thank you so much for joining us today. You can catch us every Thursday and Saturday at 5 p.m. on 1340, 1350, and 1400. We're also on Facebook and Twitter and across the web. Just search for Tampa Home Talk. In studio today, we have Perry Gruman. We're talking about wills, assets, trust, estate planning, all that fun stuff that nobody ever wants to talk about. Thanks so much for rejoining us. So let's share stories, because I think people relate most often to that more than anything. Like even when you and I were having a conversation at lunch, I could relate to that so much more than just, me speaking or an attorney speaking. I think people relate to other people and their stories. So you mentioned one of the frequently asked questions you get. Let's say my mom passes and I have a joint account with her. Do I have to go through probate? Her and I have an account together.
Mom's name and your name's on the account. The general answer is no, you don't have to go through probate, because Florida has a pretty specific banking statute, which was really implemented many years ago to protect the liability of the banks in allowing withdrawal of the money after the death of one account holder. So the general rule under Florida law is that whether it's a joint tenants without a survivorship or just tenants in common, the death of one account holder would not prevent the money from going to the surviving account holder. So
do they typically freeze the account or anything like that?
No.
Okay.
All you need is typically a death certificate. And actually, you don't even need a death certificate. If you and I are on an account, I can go and withdraw the money, whether it's joint tenants or
whether I put in $1 and you put 10,000
right,
or vice versa. Either person could take it out. That's
the general rule. Yes.
So, it's interesting. So you don't have a probate situation unless it's mom's account and I'm not on it.
Right. Now, in that situation, the listeners should probably know that Florida has a pay on death account, which is it's a legal fiction, so to speak, in that if you have an account just in your name, you can designate a pay on death beneficiary, and that person, if it's properly signed and the paperwork is done right, that person can go to the bank after the death of the account holder and withdraw all the money, even though the account was only in the name of the single person. And
is that something that's part of the will, or that's in the statute?
No, that would pass outside of probate. That's sort of an exception to the rule that generally an asset that is titled in the name of an individual person would have to go through a probate process to clear the title. Florida has this pay on death exception, which allows a beneficiary, the pay on death designee, to go to the bank and obtain all the money after the death of the account holder. Which
is probably also for reasons that they would also need to take care of final expenses.
Right.
I would imagine that's probably part of the reason why that exists. Yes? No?
I think that law has actually been in effect for quite a while in Florida. That's sort of an exception to the general rule that you otherwise would have to go through probate. As to the specifics of it was probably in the same vein of a banking protection type statute. It allows the banks to resolve the money and the financial issues as it relates to savings and loans and banks, brokerage accounts, without doing otherwise we'd have billions of dollars tied up in financial accounts. Right.
So it makes sense. I know one of the things we talked about was an original copy of the original and a copy of the will. And so if you missed that on the prior part of the show, you're definitely going to want to listen to the podcast in its entirety, because it's a frequently asked question that you get, and it's certainly a question that I had. The next one is, what about when a child is disinherited? Like, can they do that? Can my mom or her dad, can they disinherit?
They absolutely can, but in your case, Katrina, I can't imagine why they would want to do that.
I'm just throwing myself under the bus, using me as an example. So let's use your case, Jen. You're kind of in the background listening in. She's our radio show coordinator, but you've known you for many, many years. Your mom passed, dad's not remarried, but there's you and your sister.
Right.
So could her dad disinherit her and her sister from the will?
And the answer to that is yes. And it is often done under Florida law. Anybody can be disinherited except generally a spouse. Florida has what's called an elective share, which protects spouses, so that if a husband or wife attempts to do a will and says, I leave my spouse nothing, Florida law would allow the surviving spouse to claim an elective share, which in broad terms is 1/3 of the estate, generally speaking, so that the surviving spouse is guaranteed at least a minimum amount from the estate.
So even if they left, like what if someone intentionally left in their will, and I'm playing, devil's advocate, but let's say someone intentionally left in their will to leave a spouse, I don't know, $5,000 and their estate's worth $1 million. Possible?
The elective share would protect the spouse, except in larger estates like that. Florida law allows a written waiver of the elective share so that you can contractually waive your right to receive the elective share.
But the receiving spouse would have to do that, correct?
That's correct. And that's typically done in connection with either a joint will made with both spouses or a prenuptial agreement or postnuptial agreement.
We talked about that. We're going to share on that too if we have time. So let's talk about minor children. And I use the example. So there's myself and my husband. We have a will, which is a very good idea to have because we need to know who the guardian of our children are going to be, right?
Right.
3 of them. I mean, I shared with you as a guardian ad litem. I know the courts try to keep children together, but it's not always, they can't always do it, especially when there's 3 and they're varying ages. And the older kids kind of get left behind. But let's say, like in my case, there's myself and my husband, we go on a ride in his motorcycle and we die. And we have 3 minor kids.
Don't ever go on motorcycles.
Okay, so, we go on vacation,
I'm
whatever.
just kidding.
Or the kids make it and we don't. So they're minor children. What happens in that interest?
Okay, so hopefully you have a will. Hopefully in the will
I don't. I actually need to redo it. I did one on a laptop years ago, and I realized after our conversation, I'm going to make an appointment with you next week. So let's talk about both examples.
Okay.
I don't have a will, and I have 3 minor children.
Okay, so in that case, in terms of, and you're addressing who would sort of take care of the children after
Yeah,
you
what
die.
would happen with the kids? What would happen with the assets? What would happen to our home, that they live in, that they know their bedrooms, they know their schools?
Okay, let's talk about the kids first. Their guardianship of the kids relates to both guardian of the property of the children and guardianship of the person or the guardianship of the children themselves. Under Florida law, if both you and your husband passed away, then a guardianship court would determine who the guardian would be appointed to take care of the children.
So they would assign a guardian ad litem?
It would not. It's not a guardian ad litem. It's really, it would be called, it's either a guardian of the person or a guardian of the property. If it's a guardian of the person and property, it's called a plenary guardian, an everything guardian. In your case, it would be a everything guardian. But it doesn't always have to be the same. In some rare circumstances, the court can appoint one person to be the guardian of the person and another person to be the guardian of the property. It's typically the same. But my point there was that it's important in your will to appoint a guardian, that it's your intention that if my spouse does not survive me, I appoint my mom, my dad, my sister, my brother, a trusted person.
Is a very good
guardian.
point because, I love my family and I'm not going to mention any names, but there's certain family members that the courts may, I guess give my children to that it might not be mine and my husband's wishes.
Right.
Is the best way to say that.
And in that situation, assuming there's assets in the estate, which there often is, and a guardian is appointed, that typically that guardian is going to be in charge of the property also. And you normally want to avoid guardianship of the property if you can, because it's expensive, it's court supervised, there's annual accountings and inventories you have to file. It's a pain.
So I could let's take us to the other extreme. Now I'm preparing a will. I could list everything, right, including who would sell my property and put that money into a trust.
Typically, what we would do, we would included in the will, we would include what's called a testamentary trust, and what that is a clause that essentially, upon your death, creates a trust for the benefit of the beneficiaries named in the will, which is typically, in your case, your spouse and or children. And in that connection, you would appoint a trustee of the trust. And you could appoint, trustee could be a family member or non-family member. You can appoint co-trustees. The co-trustees can act independently, or you can require that they act together. You can appoint successor trustees if something happens to the initially appointed trustees, or they don't want to act. They don't want to assume that responsibility after you pass away, or they're unable to assume that responsibility, and that avoids the entire guardianship of the property problem. It doesn't avoid necessarily the guardianship of the person. Someone still has to typically be appointed by the court as guardian of the person.
But well, there's a lot of layers. I mean, even at my age, I've worked a lot for everything I have. There would be life insurance payments, a lot of those things that I would want set up in a trust for my kids that someone wouldn't blow through, that by the time my children were 18, there's nothing left.
Right. And usually if we prepare a testamentary trust as part of the will preparation process, the specific terms and conditions, of course, are determined by the client, but sort of a general framework we do if there's minor children, we provide that the trust is for the health, education, welfare of the child, and for both primary, secondary, and college education for the child, and would not terminate until the child is at least, for example, 25 years old, so that when the child turns 18, they don't get $1 million and then go
blow it all.
Right.
Yeah.
Exactly.
So could you put limits on that for even caring for the children and that type of stuff?
Absolutely.
Okay.
You can structure it. You can limit annual distributions. You can specify that it's for undergraduate school, graduate school. You can specify housing if you want. We normally don't get that specific because you typically want to leave a fairly broad range of discretion in favor of the trustee, because otherwise there's so many rules and conditions it can become problematic, because as we all know, circumstances change and you don't foresee a lot of things that are going to happen, and you often need to change.
So let me ask you this, just for the sake of time, because we're almost out. So someone is like me, and they're thinking, hey, I need to probably think about this and plan and prepare for this. Just a will on my laptop is not sufficient. I need to get an original witness, with an attorney, all that stuff. Do you have a checklist that you guys provide that are just a list of information that we can bring to your office to keep the process systematic?
I do, a very short one, but yes.
Awesome.
Yes.
Well, we're going to get that from you, and then we are going to post that on our website, which is Tampa Home Talk, and tampahometalk.com. We're on Facebook and Twitter, and we're going to see if we can get some appointments to follow mine there next week.
Awesome. Thank you.
Thank you so much for chiming in today. We really appreciate you listening to us every Thursday and Saturday at 5 p.m. We'll be on 1340, 1350, and 1400, and also across the web and via podcast after the fact. And as always, our motto is love where you live, or we are going to fix it. But today is the last of our show, and we are out.
'Cause it's a long, long way from home. There's no reason to belong. How we end up here at all. And I think it's time to
love where you live, or my mommy will fix it. And we're out.
Ask me about an inside secret to save several hundreds of dollars on your annual homeowner's insurance premium. Text the word WIND, W-I-N-D, to 813-377-2775. Again, 813-377-2775.
Hi, this is Melissa Rogers, owner of SEC Inspection Services. We're so glad that you're listening today, that we're offering you a special deal. If you're purchasing a home, you can have $50 off your full home inspection. And if you're already a client of ours, we're offering 10% off of any other service that we offer. Just give us a call at 727-786-4663 or visit us on the web at secinspection.com.
Curious what your Tampa home is worth? Here's an easy way to find out what homes like yours are selling for in today's market. Text the word VALUE to 813-377-2775 for a free report on Tampa house prices. We'll send you a free report with up-to-the-minute statistics based on all homes for sale sold in your neighborhood over the last 6 months in all price ranges. To get your free report on Tampa Bay house prices, just call or text the word value to 813-377-2775.
If you are a real estate agent and want to keep more of your hard-earned commission, call me today at 727-538-9200 extension 2. This call will change your real estate career.
Curious where your credit score is? Text the word credit to 813-377-2775. Not sure where it needs to be in order to buy? We'll tell you. Simply text the word credit to 813-377-2775 for access to your credit score now.
Hi, I'm Ike Antonio Thomas, Director of Salitas House, where we offer homeownership workshops, pre-purchase counseling, foreclosure intervention counseling for homeowners at risk of losing their home, financial coaching for adults and teens. Come sign up for our program where if you save $1,000, we'll give you $1,000. Call us 813-425-4847. Again, 813-425-4847. You can like us on Facebook or you can find us on the web, salitashouse.com.